opportunity. Our intent with these webinars is to touch on a wide array of interesting and timely topics. So we're from the law firm of Strigberger Brown Armstrong. You probably already know that if you're here, or SBA as we're more commonly known. And I have the pleasure of introducing my partner, Fiona Brown. We are both in the Toronto office, still working in a hybrid fashion, like I'm sure some of you are. Our practice areas revolve around defending personal injury claims in the occupiers context under both CGL and homeowners policies, as well as in many other areas of personal injury litigation, such as MVA cases. Just a little bit about our firm, for those of you who may not know. SBA is a civil defense litigation firm of up to 21 lawyers. We are led by a female majority partnership, and we have 3 offices, one in Toronto, one in Kitchener-Waterloo, and one in London. The firm itself practices in a wide array of areas as well, not only including the defense of these personal injury claims I mentioned, but also accident benefits, priority, loss transfer disputes, coverage, property claims, and the list goes on. Feel free to reach out to any of us if you have any questions. So getting to our topic, last year, Fiona and I put out a webinar shortly after the amendments to the Occupiers Liability Act went into place. So those amendments were significant for slip and fall claims caused by snow and ice, as they put into place this legislative notice period after a slip and fall relating to snow or ice. So before we get into our topic, I will mention just a couple of housekeeping items. There will be an opportunity for any questions. So if you have any questions at all, please feel free to pop them into the Q&A button that you should see at the bottom of your screen. And frankly, we love interaction. So even if you have any comments, please feel free to throw those in as well. And we're happy to have some dialogue. Even though we can't see you, we'd like to know that you're listening and a part of our discussion today. We will also have one brief poll during our presentation, so I encourage you to answer that when it comes up as well. So with that, let's turn to a roadmap of where we plan to go today. So I'm just going to start by very briefly touching on the overview of the Bill 118 notice requirements. For those of you who may not be familiar, we'll talk very briefly about a recap on the case law that defines reasonable excuse, which is the area that we're narrowing in on today. And Fiona is going to talk to us about a case where the reasonable excuse definition has been interpreted by the Court of Appeal more recently. That's the Sela and Capsalis case. And then she'll talk to you about some takeaways and we can have some dialogue after that. So like I said, we already touched this Bill 118 topic previously, but just as this brief refresher, because of the amendments, it's now known as the Occupiers Liability Amendment Act 2020. And the changes that we're talking about went into effect on January 29, 2021. So that's where you need to be mindful of the new notice requirements for slip and fall claims revolving around snow or ice. And you'll see on your screen there a brief refresher how these claims apply, and the fact that the plaintiff is now barred from bringing an action unless they give notice within 60 days after the occurrence of the injury to at least one occupier or independent contractor employed by the occupier to remove snow or ice. The notice has to be in writing. It has to include the date, the time, and the location of the occurrence. It has to be delivered by personal service or registered mail. There are a number of other components to the amendments, including notice requirements on the occupier or contractor to then give notice to anyone else involved. But for today, we're really just going to try to focus in on the exceptions to the requirement to give notice, as I mentioned. So on your next slide there, you'll see the exceptions to the notice requirement, of course, are the death of the injured person occurring as a result of the injury. And then you'll see the other 2 exceptions there, which are reasonable excuse. It's 2 parts actually. So reasonable excuse for the lack or sufficiency of the notice and the fact that the defendant is not prejudiced in its defense. So before we see any case law of substance in interpreting these new amendments, as we've said previously, if you tuned into our earlier webinar, we have to look to the case law interpreting a similar provision under the Municipal Act 2001 and the City of Toronto Act 2006 for guidance on how reasonable excuse has been interpreted in the case law. On my next slide here, you'll see just a very brief summary of what some of those cases have concluded on reasonable excuse. Of course, under the legislation that those cases we're dealing with, that's a more stringent 10-day notice requirement for municipalities. But you'll see a general trend here. Of course, on the check column, the green column, these are, fact situations where reasonable excuse has been found to apply. So that would be the lack or delay of knowledge of the severity of the plaintiff's injury. That was gone into great detail by the Court of Appeal in Crinson in the City of Toronto back in 2010. And in that one, you'll see situations such as the plaintiff experiencing a lengthy period of rehabilitation or declined mental state, something to show that the plaintiff could not turn his or her mind to the notice requirement within the required time. And that's been considered a reasonable excuse. And of course, it might surprise some people, but personal life circumstances is on there, where that was honed in by CEIF and City of Toronto by the Court of Appeal again, where Justice Hoy made it clear that one example of a reasonable excuse could be a situation where a plaintiff is involved in a slip and fall injury incident and sustains injuries. But they have, a child who has a life-threatening illness that requires a lot of the parent's time to try to deal with that. And even though the child's circumstance isn't directly related to the parent, it does constitute a reasonable excuse in Justice Hoy's example. And the case of Azay and Legendre, you'll see that as well, where if the plaintiff is not capable of forming the intent to sue and they don't have adequate representation to assist them with the notice, you're going to see that fall into the category of acceptance of a reasonable excuse. And on the flip side, of course, where the no column you'll see on your screen, ignorance of statutory time limits, not always going to be accepted. Courts have made it pretty clear that the lack of awareness of the notice requirement does not constitute reasonable excuse on its own. Also, the delay in seeking legal advice, so long as the plaintiff had, the physical and mental wherewithal to consult counsel within a reasonable period of time after their fall, the court again is not going to have much sympathy for that as an excuse, and in fact have not considered it to be reasonable. And then finally, of course, the flip side of the green column, if the plaintiff is found to be mentally and physically able to provide notice, the Ontario Court of Appeal in Arguin Township has said that will constitute a reasonable excuse. So then a more recent case that came out after our last webinar on this topic is Graham and City of Toronto. That's a 2021 case. So it came out in April of last year, and then the Court of Appeal had a look at it just this past February. It's a trip and fall case. And in that one, the plaintiff sued the City of Toronto for injuries she sustained when she tripped on a large, deep pothole. Anyone who lives in the City of Toronto, I'm sure you've seen a few of those lately. And this was at a pedestrian crosswalk. The injury she sustained mostly revolved around a right shoulder rotator cuff tear, but she also had some right elbow, arm, and hand issues and general other soft tissue injuries. She ultimately underwent surgery more than a year after the fall, and that was followed by extensive physiotherapy. She also had a high demand job at a capital investment firm that demanded a lot of her attention, and her recovery was more arduous and lengthier than she expected. So there ultimately was a 3-month delay in providing notice to the city, keeping in mind that under the legislation, she would have been required to give that notice within 10 days. So ultimately, the city brought a summary judgment motion on the basis that the plaintiff did not provide sufficient notice of her claim. And ultimately, when the lower court looked at it, they found that the plaintiff was able to demonstrate a reasonable excuse for why notice was not provided earlier, which meant that the city's summary judgment motion was dismissed. They found, interestingly, that there's no prejudice in this one to the city from the late notice, and that was upheld by the Court of Appeal this past February. It's important to know, though, that this was a trip and fall claim, not a slip and fall, which is what the Occupiers Liability Amendments tend to focus on because of the involvement of snow and ice. We think that's pretty relevant because if you think about the influence of the prejudice suffered by the occupier, it might allow a court to be more lenient with a slip and fall claim versus a trip and fall. With a trip and fall, arguably have a better chance of investigating the incident in that instance. It's very different from the context of a slip and fall claim where, especially one caused by snow and ice, the occupier is precluded from getting that crucial evidence closer to the date of the incident, such as photographs and witness information and all of the things that help to reduce the prejudice element on the occupier. So keep that prejudice in mind as we talk about the reasonable excuse category, because it does seem to have some sort of a relevant bearing when you look at the cases. So that's sort of a recap on the history and developments that have happened up to the more recent Court of Appeal case that Fiona is going to talk about. And with that in mind, I will now turn it over to Fiona to introduce herself and take us away.
Thank you, Krista. And hi, everyone. Thank you so much for joining me and Krista today. As Krista mentioned, I'm going to be talking predominantly about the recent Court of Appeal decision in Sala and Capsalis. It upholds the lower court's decision, and it provides us some guidance as to what constitutes reasonable notice under the Occupiers Liability Amendment Act. I want to start out first by saying that the framework in this decision is not the Occupiers Liability Amendment Act, it's the Municipal Act, which contains an almost identical notice requirement to the Occupiers Liability Amendment Act. In the Municipal Act, as I'm sure most of you know, that in cases involving municipalities, written notice must be provided within 10 days of the event. And like the Occupiers Liability Amendment Act, failing to give proper notice is not a bar to bringing the action if a judge finds there was a reasonable excuse and that the defense suffered no prejudice. I also want to point out that in this decision, we're not dealing with a trip and fall or a slip and fall, but in fact, we're dealing with a motor vehicle accident. But again, because of the virtually identical notice requirements, it is applicable to the Occupiers Liability Amendment Act. So I'll start out with some background information, and what you're going to see or what you're going to hear is I'm going to be bringing up quite a number of dates. It's just because of the circumstances of this claim where dates and notice are important. The claim revolves around a motor vehicle accident that occurred in the city of Toronto on March 28, 2015. Notice was not given to the city of Toronto for about 3 years on April 2nd, 2018, which far exceeds the requirement under the Municipal Act. The city of Toronto brought a summary judgment motion. Now, the issues for the court were, first of all, whether or not the case was appropriate for summary judgment, as well as whether or not the plaintiff had demonstrated that they had a reasonable excuse for failing to provide timely notice. Now, because the parties before the motion started had agreed on all of the facts, which is not always the case in a summary judgment motion, but they had in this case, which meant there would not be any issues with credibility. Therefore, the court felt this was an appropriate case for summary judgment and agreed to hear the motion. In terms of the facts related to the notice requirement, again, it was a motor vehicle accident. It occurred at an intersection in Toronto where both the plaintiff and the defendant were turning. And ultimately, the plaintiff struck the rear of the defendant's motor vehicle. The plaintiff retained counsel shortly after the accident, and counsel provided the appropriate notice under the Insurance Act of their intention to sue and bring the claim on the defendant driver. About a month or two after giving notice, plaintiff's counsel requested and obtained the complete police file. Now, in that file were a couple of statements, one given by the plaintiff to police and one given by the defendant to police. And as is often the case, the statements were quite different. So they were almost opposite in their description of how the accident occurred. And it was obvious there was a discrepancy between the defendant and the plaintiff in terms of how they saw the collision occurring. Shortly thereafter, the plaintiff issued their statement of claim in December 2015, and the allegations of negligence against the defendant were very broad, as we often see. The defendant driver served and filed their statement of defense and jury notice a few months later, and there they alleged a few things. Number one, that the plaintiff's negligence caused or contributed to the collision. They alleged that the plaintiff had the last clear chance to avoid the collision. And thirdly, they alleged that the plaintiff had failed to keep a proper lookout and pay adequate attention to the road. These are quite broad allegations, but it certainly was obvious they were in part blaming the plaintiff for the collision. The examinations for discovery were scheduled in January and February 2017. And before the discoveries took place, the defendant provided to plaintiff's counsel a number of photographs that had been taken at the scene shortly after the accident. So plaintiff's counsel had these photographs in possession by the time of the discovery. About a year after the examination for discovery in February 2018, the defendant served and filed an engineering report blaming the plaintiff for the accident. The report suggested that the plaintiff had sufficient time to avoid the accident and put the plaintiff's perception of time into issue. What's interesting is that this report doesn't address at all the design of the intersection in question, and does not suggest that the design of the intersection in any way affected the plaintiff's reaction time. Shortly after that, as suspected, plaintiff's counsel went out, got their own engineer, and their engineer told plaintiff's counsel in March 2018 that in an abundance of caution, plaintiff's counsel should put the city on notice as there might be potential negligence against the city. So we're looking at about 3 years after the accident when plaintiff's counsel, their expert, tells them of this possibility. So plaintiff's counsel did what they should do. They immediately, a few days after getting this information from their expert, they put the city on notice as they were required to do under the Municipal Act. But the city was not added as a defendant to the lawsuit for about another year. Then what was really odd is 2 weeks after the city was added to the statement of claim, so in April 2019, they amended the claim and for the first time suggested that there was a design flaw to the intersection where the accident occurred that caused or contributed to the accident. So this is actually about 4 years after the accident that this information was first expressed to the city. So the plaintiff argued that they had not considered the possibility of a design flaw until after they had hired their experts to respond to the defendant's report, which again, I'm going to reiterate, didn't comment on a design flaw. Now, the court accepted that there was no question that once the plaintiff got the information from their expert and were advised the city may be somehow exposed for this collision, they immediately gave notice to the city, which was what they should do. But the court said that's really not the issue here. That's not the question that they have to address. And they said the question they have to address is, does waiting to hire an expert engineer who raised the possibility of a design flaw after receiving the defendant's expert report constitute a reasonable excuse that would justify the late provision of notice to the city. Now, the lower court, when they start their analysis, they confirm that in such a case, it's the burden is on the plaintiff or plaintiff's counsel to prove that they have satisfied the reasonable notice requirements. They offer a good definition for us as to what is a reasonable excuse. And they suggest that a reasonable excuse is the inability to have discovered sufficient facts to have reasonably discovered a potential claim despite due diligence. And I think that's key, despite the due diligence. Now, important considerations for the court would be the plaintiff's legal capacity, the length of the delay, the explanation for the delay, and when the plaintiff came into possession of the material facts necessary to determine potential liability against a party. The court made it clear that a plaintiff does not have to be certain of their ability to prove their claim to trigger the notice requirement. They only need sufficient facts to base a potential claim. So in this case, the only explanation offered by the plaintiff for delaying to put the city on notice was that they had not considered the possibility of a design flaw at the intersection until after they got their engineering report, and they did not have knowledge of sufficient facts to know there may have been a potential claim against the city. So you've heard the evidence, you've heard the reasonable excuse the plaintiff made. We're going to do a little poll. So we've got a plaintiff here who basically says, it's been 3.5 years. I had no idea that there could be a potential design flaw until after I got my expert opinion, despite doing examinations for discovery, despite having the pleadings. So what do you think? Yes. Did the plaintiff have a reasonable excuse, or no, they did not? Okay, so it looks like, well, 63% of you say no, and 38 say yes. Well, those of you who said no are correct. The court disagreed with the plaintiff, and here's why. The court felt the plaintiff and his counsel, they knew the location of the accident. They knew the city had the responsibility of designing the intersection in question, and they knew that the defendant was blaming the plaintiff for not avoiding the accident. The court felt that the police statements and the discovery evidence should have led a reasonably prudent plaintiff to have investigated the intersection and put the city on notice. And I think what was important for the court is, they said at the very latest, what they should have done is once they got that defense engineering report back in February 2018, that should immediately have been a red flag for the plaintiff. And the plaintiff should have then put the city on notice, but they didn't. Instead, they went out, they got their own engineering report, and then waited 2 months after getting their report, or sorry, they waited 2 days after getting their report for putting them on notice. But I think that what was important for the court in finding that is, when you think about it, providing notice to the city is not something onerous. It's something very simply that could have been done, but wasn't. And also, when a plaintiff gives notice, that doesn't commit the plaintiff to going out and actually bringing the lawsuit. So I think that was an important consideration for the court. The court also pointed out that the degree of knowledge that's required to trigger the notice requirement is only the event itself, as opposed to the discoverability requirement under the Limitations Act, which would require a significant amount of knowledge. So the court concluded that the plaintiff did not have a reasonable excuse to justify their delay in providing notice. Well, the plaintiff appealed to the Court of Appeal, and the Court of Appeal decision was extremely short. They unanimously agreed with the lower court's finding and reasoning, and they based their opinion, their finding that, and found that at the very latest, the plaintiff's counsel should have provided the city with notice within 10 days after receiving the defense expert report, which again, I'm going to point out, did not mention anything about a design flaw, but that was the Court of Appeal decision. So after listening to this and after reviewing the case, I think there are some takeaways for all of us. First of all, if you're contemplating bringing a summary judgment motion, if the facts of the case are not agreed upon before bringing the motion, even just a few facts that you disagree with the opposing counsel with, there's no point in bringing the motion, because credibility would then come into play, and it would not be an appropriate case for summary judgment. The court is a good reminder for us that it's up to the plaintiff to lead evidence and establish that they have a reasonable excuse for the notice delay. I think it's obvious that all of these decisions, when it comes to reasonable notice, are going to be fact specific. There's no general rule. All of the facts have to be looked at. I think one of for me, the important takeaways is that waiting to receive an expert opinion may not be a reasonable excuse if available evidence is available to identify the possibility, just the possibility of a claim, such as a police report, snow logs, CCTV footage, an incident report, and even the allegations of negligence in a defense, or the allegations in a statement of claim. If any of this raises the mere possibility of a potential claim, I think notice should be given. Because in this case, if the plaintiff had just put the city on notice after getting the defense report, they would have been, that the city would have been unsuccessful in getting summary judgment against the plaintiff. So my advice is, if we're in a situation where notice must be given, give it early. There is no downside whatsoever, and we protect ourselves by doing so.
Very, very excellent.
Thank you.
Thanks for that. And something that resonated with me that you were discussing was we keep seeing this attitude from the judiciary about the importance of early everything, but especially early expert reports. I mean, we see it from the more recent changes to the rules of civil procedure just this past March, where the expectation is that parties can't be thinking about these expert reports on the eve of pretrial. This has to come, certainly by the time of discoveries, or certainly within a reasonable time period after that. And we're seeing that in this decision, right? That's exactly what the court was highlighting, it seems to be as well.
Yeah, most definitely. That's a real shift in our court system. The other thing I'm curious, I don't know if anyone in the chat wants to just comment if you think this is a fair decision. We should have done a poll, because I'm quite curious if how you all feel about this, if this was fair. I don't know if you could put a comment or two in the chat. I would just be very interested in hearing. Fair?
Yeah, Beth Ann says fair. Yeah, and I think that we see some mixed results here, obviously, right? So, and by the way, if anyone has any other questions at all, feel free to pop them in now. But any comments on that? We've got 2 fairs.
Fair. Yeah, and I guess my one comment would be that the plaintiff didn't know, or is suggesting they didn't know of a potential design flaw until getting their own expert report. And that's what stood out for me. But on the other hand, we're talking 3-4 years after a claim, and obviously the court felt the plaintiff did not either do his due diligence or just give notice to protect his client.
Right. We do have a question actually in the Q&A here, Fiona, which is, do
Okay.
you think the court would consider a notice of incident and injury, i.e. completing an incident report form for the occupier, to be the same as notice of a claim?
I don't think so, Krista. I think written note, I guess the question is whether or not that would be enough for written notice.
I tend to
I
agree.
don't think so. I think you still are obligated to send your letter, as Krista pointed out.
And that's it. I think because at least with the Occupiers Liability Amendment Act amendments, they are very specific about what you need. So I suppose if all of that information was contained in that report, yes, as long as that's being given to the occupier within the time period and it checks off all those boxes, it could. But if it doesn't, then that's not going to constitute the type of notice subject to these exceptions anyway. So
yeah, I would be worried because I think in the notice letter, you would say something along the lines of, please accept this as your notice, you may be held responsible, or something along those lines. So I would be a bit concerned. I would prefer to give the fulsome written notice as required by the Act.
perfect. And of course, if any of you out there have any specific questions, we've offered some assistance to people even after our last webinar about how to craft this sort of notice letter. Please feel free to reach out to Fiona or myself, and we're happy to run it through with you or give you any sort of helpful tips on that. But I see we're already a little bit over our time. So good discussion today. Thanks so much, everyone, for joining. I did want to let you know that our next SBA Lunch and Learn webinar is coming up on June the 16th. It's going to be hosted by our very own Daniel Strigberger, and his topic is going to be 44 in 30, foraging the family protection endorsement. So if you're able, we invite you to join us for that, and stay tuned, of course, for any future webinar invitations that we have. We run these all the time, and we really love any feedback and interactive engagement that we can get. So please feel free to reach out anytime. Thank you again.
Great. Thanks, everyone. Take care.